information instead of the media or the public with bits and pieces of information. Neama, I agree with that to a certain extent, but and I think Loretta said it's something about the toothpaste is out of the tube already on this one. Do you think it's better for society to see everything ahead of time, or better for things to come out during this trial?
Look, normally I want to protect the rights of the criminal defendants, but in this case, the defense attorneys want to release the video to the public. They're the ones who are attaching those transcripts to their filings. I don't know what Judge Cahill is doing here. He's allowing the media to view the videos, but not allow the public to see it. Makes zero sense. Never seen this in my years of practice. So respectfully, Lynn, I'm going to have to disagree with you. The public has an absolute right to view this footage, parts of which have already been seen by members of the media. So I see no basis for it to deny the public at large the same right.
Liz writes tonight, there are always two sides to every story. Would love to hear all sides. Also, the jury will hear what was already released and see what the defense has. It makes it an even playing field. Loretta, I'm looking at this case, and I haven't had one guest on the show who said, oh yeah, it looks like there's a whole bunch of reasonable doubt floating around this one. I mean, I'm usually surrounded by all criminal defense attorneys every night. I can't find one criminal defense attorney to say that. I'm wondering, when they do pick a jury, you have to find 12 who say, listen, I haven't made up my mind. I can go either way on this one. Who are those people? And where are they going to come from? Because they're going to find them eventually, and I'm just wondering who they are, because I'd like to talk to them.
Exactly, and especially whenever it comes to the officers on the aiding and the abetting, I wish that one of those officers would have tapped Officer Chauvin on the back and say, hey, go stand over there. I got this. And I see that a lot on police tapes, where people are people. We get flooded with emotions, so we need to have that teamwork to say, hey, stop. But the law doesn't really require the other officers to act that way. They just need to make sure that they're not doing anything intentional, reckless, or negligence to cause the furthering of a crime here. But at the end of the day, we all wish that things were done differently. And I don't know how a jury is going to deal with all of these facts.
Vinny,
Sharon tonight writes,
I'll try to come up with an argument there.
Go ahead.
I'll try to come up with one for the aiding and abetting. So the manslaughter, Lane is done. There's no possible way he's going to get out of it. I mean, that's gross negligence. On the aiding and abetting, because you need that specific intent, that mens rea, he has an argument that he did not intend to assault Floyd. Now, the assault is the key point, right? The state attorneys general, they did a great job charging this, because they didn't charge second-degree murder. They charge felony murder, which just requires the intent to commit assault. So it's going to be a tough argument. I see what Lane's attorney is doing, but I think that's the only shot they have of a not guilty verdict. It'd be on that count. I don't agree with it, going to put it out there, but I think they have a shot. They have zero shot on the manslaughter charge, because that just requires the gross negligence.
And again, Lane is not the one with his knee on the neck. He's down by the feet. He's the